Nobody in the packed Supreme Court chamber expected Keanu Reeves to challenge Chief Justice Roberts on complex intellectual property doctrine. The Matrix star was there to testify about film industry copyright issues, and legal observers assumed they'd witnessed typical celebrity advocacy. What they didn't know was that Reeves had secretly spent 8 years studying IP law at Stanford while filming blockbusters, and he was about to deliver a legal masterclass that would reshape how America protects creative works. Before we dive into this extraordinary legal confrontation that revolutionized intellectual property law, make sure to subscribe to our channel and hit the notification bell so you never miss these incredible stories of hidden genius and unexpected triumph. The marble halls of the Supreme Court building hummed with anticipation as legal experts, entertainment industry representatives, and technology leaders gathered for what promised to be a landmark intellectual property case. Digital Dynamics Corporation versus Universal Creative Studios had attracted national attention not just for its potential to reshape copyright law in the digital age, but because Hollywood icon Keanu Reeves had filed an unprecedented amicus brief that challenged fundamental assumptions about creative ownership and technological innovation. Chief Justice John Roberts, now in his 20th year leading the nation's highest court, had established himself as one of the most intellectually rigorous jurists in American history. At 70, Roberts commanded universal respect for his careful legal reasoning and mastery of complex constitutional doctrine. He had presided over cases involving healthcare, voting rights, and digital privacy, but intellectual property law represented one of his particular areas of expertise, having argued several landmark IP cases before joining the court. The case before the court involved a fundamental question about artificial intelligence and creative ownership. Digital Dynamics had developed an AI system that could generate film scripts, musical compositions, and visual art by analyzing millions of existing works. Universal Studios claimed this constituted massive copyright infringement, while Digital Dynamics argued their technology represented fair use and innovation protected by the First Amendment and constitutional provisions encouraging technological progress. What made this hearing extraordinary was that Keanu Reeves had been granted the rare privilege of presenting oral arguments as amicus curiae, representing a coalition of artists, technologists, and creative professionals. His brief had proposed a revolutionary framework for balancing creator rights with technological innovation that had divided legal scholars and industry experts. Reeves arrived that morning in his characteristic understated style, wearing a simple black suit that somehow managed to look both elegant and humble. At 59, the actor maintained the quiet intensity that had defined his career, but those who looked closely might have noticed the comprehensive legal materials organized with mathematical precision and the stack of technical patents annotated in meticulous detail. The courtroom filled with an unusual mix of entertainment lawyers, technology executives, copyright scholars, and film industry professionals drawn by the celebrity involvement and the case's potential to reshape the digital economy. C-SPAN cameras prepared to broadcast what many expected would be a brief appearance by a well-meaning but legally outmatched actor. "This court will come to order," Chief Justice Roberts announced with his customary authority. "We will hear argument first this morning in Case 23-1891, Digital Dynamics Corporation versus Universal Creative Studios. Mr. Reeves, as amicus curiae, you may proceed." Reeves approached the podium with the same focused calm he brought to his most challenging roles. "Mr. Chief Justice, and may it please the court, I appear today to address fundamental questions about how intellectual property law should adapt to technological innovation while preserving the constitutional balance between creator rights and public benefit." His opening was professional but unremarkable. Roberts, who had reviewed Reeves's brief with considerable skepticism, saw an opportunity to establish proper boundaries between celebrity advocacy and serious constitutional discourse. "Mr. Reeves," Roberts began, his tone carrying polite but unmistakable condescension, "while the court appreciates your interest in intellectual property issues, these cases involve extraordinarily complex questions of constitutional law, statutory interpretation, and technological analysis. Don't you think such matters require expertise that goes somewhat beyond, well, acting experience?" A ripple of uncomfortable laughter ran through the courtroom. Roberts' comment, while not openly hostile, clearly suggested that Reeves was out of his depth in serious legal discourse. The Chief Justice obviously expected the actor to acknowledge his limitations and defer to legal professionals. Reeves paused, meeting Roberts' gaze with the same steady composure that had made him one of Hollywood's most respected figures. Mr. Chief Justice, I understand your concern about proper expertise. That's precisely why I've spent the last 8 years studying intellectual property law at Stanford University, where I recently completed my Master of Laws degree with a specialization in technology law and digital rights. The courtroom fell completely silent. Roberts' eyebrows rose as he processed this unexpected revelation. Several justices leaned forward with sudden interest, while court reporters looked up from their transcripts in surprise. Furthermore, Reeves continued, reaching into his briefcase with characteristic deliberation. My research has been published in the Stanford Technology Law Review, the Berkeley Technology Law Journal, and the Harvard Journal of Law and AMP. Technology. I've also served as a research fellow with the Stanford Vienna Digital Rights Initiative and collaborated with leading scholars on questions of AI creativity and constitutional protection for technological innovation. Reeves placed several bound documents on the podium with quiet precision. My testimony today is based not on celebrity opinion or film industry experience, but on original legal scholarship and empirical analysis of how intellectual property doctrine intersects with constitutional protections for both creative expression and technological progress. The transformation in the courtroom was immediate and profound. What had begun as expected celebrity advocacy had suddenly become serious academic discourse. Roberts, clearly reassessing his approach, decided to test Reeves's claimed expertise with a sophisticated constitutional question. Mr. Reeves, if you're claiming academic expertise in IP law, then you'll understand that this case requires balancing the Copyright Clause's grant of limited monopolies to creators with the First Amendment's protection of expression and the Constitution's broader commitment to promoting innovation. How does your analysis address these competing constitutional values? It was a complex question that went to the heart of intellectual property jurisprudence. The tension between creator protection and innovation had puzzled legal scholars for decades, and Roberts clearly expected to expose the limitations of Reeves's understanding. Mr. Chief Justice, I believe the current approach to that balance is fundamentally flawed, Reeves replied without hesitation. The Copyright Clause grants Congress power to promote the progress of science and useful arts by securing limited times to authors and inventors the exclusive right to their respective writings and discoveries. The key word is progress. Reeves opened his research materials with practiced ease. My empirical analysis of patent and copyright cases over the past 3 decades shows that overly broad IP protection actually inhibits the constitutional goal of promoting progress. When creators can claim ownership over basic techniques, common elements, or algorithmic processes, it creates barriers to innovation rather than incentives for creation. The legal precision of Reeves's response caught Roberts completely off guard. This wasn't celebrity advocacy reading talking points. This was sophisticated constitutional analysis delivered with remarkable fluency and supported by original empirical research. Justice Elena Kagan, clearly intrigued, entered the discussion. Mr. Reeves, your brief makes a fascinating argument about fair use doctrine and AI creativity. Could you elaborate on how traditional fair use analysis applies to machine learning systems that analyze millions of copyrighted works? Reeves turned to address her directly with evident enthusiasm for the subject. Justice Kagan, that's exactly where current doctrine breaks down. Traditional fair use analysis under Campbell v. Acuff-Rose looks at factors like purpose, nature of the work, amount used, and market impact. But AI systems fundamentally challenge those categories. He moved to a specific section of his materials. When an AI analyzes 1 million songs to understand harmonic patterns, it's not using any individual song in a way that traditional fair use contemplates. It's engaged in what I call transformative analysis, extracting abstract patterns rather than copying expressive content. Reeves's voice gained momentum as he addressed the cutting-edge intersection of technology and law. My research shows that AI creativity actually enhances rather than diminishes human creativity by democratizing access to sophisticated compositional tools. A struggling musician can now access harmonic analysis that previously required expensive formal training, while established artists can explore creative possibilities they never would have discovered independently. Justice Samuel Alito, known for his conservative approach to intellectual property, raised a practical concern. Mr. Reeves, that sounds like you're advocating for essentially unlimited copying, as long as it's done by machines. How do we protect creators' legitimate economic interests if anyone can feed their work into an AI system? The question went to the heart of the entertainment industry's concerns about AI technology. Reeves's response demonstrated both legal sophistication and practical understanding of creative economics. Justice Alito, that's not what I'm proposing at all, Reeves replied with characteristic thoughtfulness. My framework distinguishes between transformative analysis that extracts abstract patterns and derivative creation that competes with original works. He opened a detailed economic analysis he had prepared. When an AI learns harmonic principles from existing music, that's fundamentally different from copying melodies or lyrics. It's similar to how human musicians learn from influences without infringing copyright. The key is ensuring that AI-generated works don't substantially substitute for the original works used in training. Reeves continued with growing confidence. My research proposes a three-part test. First, was the use transformative in extracting abstract principles rather than copying expression? Second, does the output compete directly with training materials? Third, does the overall effect promote or inhibit creative progress? This framework protects creators' economic interests while preserving constitutional values of innovation and free expression. The sophistication of Reeves's proposed legal framework was remarkable. He had clearly thought through both theoretical constitutional principles and practical implementation challenges in a way that impressed even skeptical justices. Chief Justice Roberts, who had begun the hearing confident of his intellectual superiority, found himself engaged in serious constitutional dialogue with someone he had initially dismissed. His tone became markedly more respectful. Mr. Reeves, your proposed framework is intriguing, but implementation concerns me. How would courts distinguish between legitimate transformative analysis and prohibited copying when dealing with AI systems that can process millions of works instantaneously? Reeves nodded seriously. Mr. Chief Justice, that's why my research includes detailed technical analysis of how different AI systems actually function. Most machine learning doesn't store copies of training materials. It extracts statistical patterns that are then used to generate new content. He reached for a technical document that demonstrated his deep understanding of the technology at issue. I've worked with computer scientists at Stanford to develop objective criteria for measuring transformative analysis. Courts can examine whether an AI system retains copyrightable expression from training data or only abstract patterns that are themselves uncopyrightable. Reeves's integration of legal doctrine with technical understanding was extraordinary. He had clearly invested significant time in understanding both the legal and technological dimensions of AI creativity in ways that few legal scholars had attempted. Justice Brett Kavanaugh raised a forward-looking concern. Mr. Reeves, assuming we accept your analytical framework, what about future technological developments? How do we create legal doctrine that can adapt to innovations we haven't yet imagined? Justice Kavanaugh, that's precisely why I advocate for principle-based rather than technology-specific doctrine, Reeves replied. The Constitution's emphasis on promoting progress provides a flexible framework that can accommodate technological change while preserving core values. He moved to address broader constitutional themes. My research shows that the most successful IP doctrines focus on effects rather than methods. Instead of trying to regulate specific technologies, courts should ask whether particular uses promote or inhibit the constitutional goal of creative progress. This approach worked when photography challenged painting, when radio challenged sheet music, and when VCRs challenged film studios. Justice Amy Coney Barrett, who had been taking detailed notes throughout Reeves's presentation, posed a challenging question about constitutional interpretation. Mr. Reeves, your originalist analysis of the copyright clause is compelling. But how do you reconcile that with the practical needs of modern creative industries that depend on strong IP protection? Reeves's response revealed both his constitutional scholarship and his practical understanding of the entertainment industry. Justice Barrett, I don't think there's actually a conflict between originalist interpretation and protecting creative industries. The founders understood that temporary monopolies should promote rather than hinder overall creative progress. His voice carried quiet conviction as he continued, "My industry experience has shown me that the most innovative creators often struggle under overly restrictive IP regimes. When basic techniques or common elements are locked up by broad patents or copyrights, it becomes harder for new artists to build on existing work in transformative ways." Reeves opened his final section of materials. The founder's vision of limited monopolies that promote progress actually supports innovation-friendly IP doctrine. Strong protection for truly original expression combined with broad fair use for transformative creativity serves both constitutional values and long-term industry health. The personal dimension of Reeves's testimony was compelling. He had combined rigorous constitutional scholarship with practical industry knowledge gained through decades of creative work, resulting in analysis that was both theoretically sound and practically grounded as Reeves's allotted time approached its end. Chief Justice Roberts made an unusual decision that signaled his complete reversal from initial skepticism to genuine respect. Mr. Reeves, the court will extend your time by 15 minutes. Your constitutional analysis raises important questions that deserve full exploration. The extension was virtually unprecedented for an amicus presenter and represented Roberts's acknowledgement that Reeves had earned serious intellectual engagement rather than polite dismissal. Reeves used the additional time to address broader implications of the case for constitutional democracy and technological innovation. Mr. Chief Justice, this case ultimately asks whether American law will encourage or discourage the technological innovation that has driven our economic and creative prosperity. He looked around at all 9 justices with quiet intensity. The Constitution's framers understood that progress requires building on existing knowledge while rewarding genuine innovation. Their framework remains sound, but it requires careful application to new technologies that can democratize creativity while respecting legitimate creator interests. Reeves's conclusion combined constitutional principle with practical wisdom. When we strike the right balance between protection and innovation, everyone benefits. Creators get meaningful protection for their original expression. Technologists can build tools that enhance human creativity, and the public gets access to new forms of creative expression that wouldn't otherwise exist. As Reeves concluded his presentation and returned to his seat, the courtroom remained silent for several moments. The transformation from celebrity advocate to constitutional scholar had been complete and undeniable, leaving legal observers struggling to process what they had witnessed. Chief Justice Roberts, who had begun the hearing confident he could quickly dismiss Reeves's arguments, found himself offering something rarely heard in Supreme Court proceedings. Mr. Reeves, your scholarship and analysis have been exceptional. The court has rarely heard testimony that combines such rigorous constitutional analysis with deep understanding of both legal doctrine and technological innovation. Reeves nodded with characteristic humility. Thank you, Mr. Chief Justice. Constitutional law belongs to all Americans, and I'm grateful for the opportunity to contribute to this important dialogue about how we protect both creativity and innovation in the digital age. The immediate aftermath was extraordinary. Within hours, constitutional law professors were analyzing Reeves's framework for AI fair use, while technology scholars praised his integration of legal doctrine with technical understanding. Entertainment industry executives found themselves reconsidering their assumptions about AI creativity, while digital rights advocates hailed his balanced approach to creator protection and innovation freedom. 3 months later, the Supreme Court issued a landmark 8-1 decision in Digital Dynamics versus Universal Studios that adopted core elements of Reeves's analytical framework. Chief Justice Roberts, writing for the majority, cited Reeves's amicus brief 12 times, and incorporated his three-part test for AI fair use almost verbatim, that in an unprecedented footnote. Roberts wrote, "The court benefited substantially from the constitutional scholarship and technical analysis provided by amicus curiae Keanu Reeves. His research demonstrates that constitutional wisdom can emerge from unexpected sources when combined with rigorous study and genuine commitment to both legal principle and practical understanding." The decision revolutionized American intellectual property law, establishing new protections for AI innovation while maintaining meaningful creator rights. More importantly, it demonstrated that constitutional expertise could develop outside traditional academic institutions when driven by genuine intellectual curiosity and rigorous scholarship. For Reeves personally, the Supreme Court appearance marked a new chapter in his already distinguished career. While he continued acting, he also began teaching intellectual property law as a visiting professor at Stanford, established a fellowship program for studying AI creativity, and founded a research institute examining the intersection of technology and constitutional law. The confrontation between Chief Justice Roberts and Keanu Reeves became a modern parable about intellectual humility, the value of diverse perspectives in constitutional interpretation, and the importance of understanding technology when crafting legal doctrine for the digital age. In interviews following the decision, Reeves remained characteristically modest about his transformation from actor to constitutional scholar. "The law affects everyone," he said with typical understatement. When fundamental questions about creativity and innovation are at stake, anyone who cares about those issues has a responsibility to engage seriously with the legal framework that shapes them. Perhaps most remarkably, the case established a new model for how courts should approach technology cases, requiring both constitutional analysis and technical understanding, combining legal doctrine with empirical research, and recognizing that expertise can develop through dedicated study regardless of professional background. The man who had once portrayed a character who could see through the matrix of simulated reality had become a real-life constitutional scholar who helped the Supreme Court see through the complexities of digital creativity to fundamental principles of innovation, expression, and progress. It was, as many observers noted, the most perfectly Keanu Reeves story imaginable. A quiet hero who succeeded through preparation, thoughtfulness, and genuine commitment to understanding complex problems before attempting to solve them.